Hey, very good. Well, welcome everybody. My name is Marty Mascari. I am a contractor with the North Central Texas Area Agency on Aging and the North Central Texas Aging and Disability Resource Center, or ADRC, both of which are under the umbrella of the North Central Texas Council of Governments in the greater Dallas-Fort Worth, Texas area. We're thrilled to have our partners at Heyman Hogue here to talk about ethics. We've got Sheila Williamson and Fred Heyman. Fred's one of the founding partners of Heyman Hogue. But before we get started, we're going to talk a little bit about CEUs, because I know since this is an ethics seminar, lots of you are joining us for CEUs. So let's go over the guidelines and rules for that, so you got that down. Today we're providing complimentary CEUs, and they are ethics for ethics. If you need ethics, CEUs are offered for licensed social workers and licensed professional counselors within the licensed in the state of Texas. We're also offering certificates of attendance. Any of you are welcome to go through the process and get a certificate, whether you have a different license in Texas or you have a license outside of Texas, and you're more than welcome to submit those to your jurisdiction, to whoever has oversight over your license. But please know there's no guarantee that they will take it. I will tell you, I've had people tell me they have been able to use them. I have also had the jurisdictions reach out to me for copies of slides or other information in order for them to decide whether they were going to take them, and that is not a problem as well, to a certain extent, and that's not a problem. So feel free. The requirements for both the certificate of attendance and the CEUs is the same. You must be on for the entire live webinar and the Q&A up to the time that we've advertised the webinar to go, which is till 9:30 a.m. Central Time this morning. You must then also complete, I'm sorry, 11:30. I'm sitting here looking at like 11:30 a.m. Central Time this morning. The computer I'm using is on California time because I use it when I travel a lot. Sorry. And so you must complete also complete the Google evaluation survey. That should pop up as you close out of Zoom today. It should just simply ask you if you'd like to take a short survey. That will bring up our Google survey. And in there, you just tell us what certificate you're looking for. And anyone can ask for a CEU certificate. You don't have to prove that you're licensed to do it. So feel free to ask for whatever one you think you can use best. The survey link will be up, will go out also in a follow-up email tomorrow. And then the survey link will be live until February 5th. Please give us about 30 to 45 days after that to get those out to you. In fact, we're a little bit farther behind than that even. We're getting caught up, but if you could give us till at least the 5th of March, that's what that should say. But the 25th, you should have it for sure. So Sheila, I'm going to turn it over to you and let you introduce Fred, if you would.
Absolutely.
Thank you so much.
Absolutely. Good morning, everybody. It is warming up a little bit, or at least here it is, and I'm hopefully, like you, I'm very, very thankful for that. Anyway, we're glad to bring this to you today. Fred's going to tell you it's a shame that you have to teach this, but there are people that don't understand what in some cases is ethical and what isn't. And so that is why this is so important in your professions that you know this, and perhaps because you're going to see clients and patients that you could use this with as well to help them. Anyway, today we have the founding partner of Heyman Hogue, my boss, Fred Heyman, who has been an attorney for more than 25 years, but before that was a police officer. So dealt a lot with ethics on both sides. I know that he's very knowledgeable and can answer a lot of your questions, and he has a way about him that makes this a little more palatable, because ethics is not the most exciting thing to teach. Anyway, but anyway, without any further ado, my boss and your presenter, Fred Heyman.
Well, thank you, Sheila. At least you didn't tell me it's my least favorite topic to teach.
No, but I was thinking it.
Well, good morning, everybody. I see that we've got, let's see, what is the number now? 293 people on here today. So a lot of people need ethics credits. And just like I'm sure your occupation, I've heard, 6 hours, just like ours in the law, we only need 3 hours of ethics, and it's hard to get those 3 hours. And it's hard to find classes that have ethics in them, or if they do, they're a lot of the ones that we have, they'll be like a day long, and you get a half hour of ethics or whatever. So I understand why people want to get this, and I'm glad I can do this. Most of the talk today is going to be based around codes of conduct and ethical behaviors, mainly for social workers. But the reason I do it that way is because the code of conduct and the ethical behavior rules when it comes to social workers is pretty much the same as anybody in the medical licensed therapist type field. We all have a lot of the basics in almost every occupation. And yes, as Sheila said, when I first started doing this, I would say it's a shame you even have to teach ethics, because there should be, most people know right from wrong, and they know they should do right and they shouldn't do wrong. But ethics, really, when it comes down to it, when you really start looking at it, as you see when we start examining this, it's not that simple. It's not that cut and dry. And it's not always a right or wrong. And sometimes the right thing might fall in or outside of the code of ethics or the code of conduct. So let's go ahead and dive on in. Let me see if I can get my clicker to work. So what exactly is a code of conduct? These you hear your rules of ethics, codes of conduct, you hear all these kind of different terms. But a code of conduct, really what it comes down to is it rules, principles, values, and standards that guide behavior within an organization, within an occupation. It explains the expectations and the responsibilities of the organization. And when it really comes down to it, it's more than just the organization. It's really the occupation that we're talking about when we look at codes of conduct. Certain businesses have a code of conduct, and this is the way you're supposed to act and behave here at the workplace. But there's also codes of conduct that dictate our occupation and what our occupation is supposed to do. Ethical behavior, on the other hand, is the act of doing what's right based on moral principles and values. That sounds pretty cut and dry and pretty easy. But as you see when we go through more of this, ethical behavior is not just that cut and dry. It's not just doing what's right based on moral principles and values, because moral principles and values fluctuate, and society's morals, principles, and values change from culture to culture and from generation to generation. Things that we are seeing as politically correct today weren't worried about or weren't seen as the concern of being politically correct 20 years ago. And so though there is that fluctuation that goes through and was the behavior and was the way we looked at things correct 20 years ago, 40 years ago, or is it today? It really is based on what is going on in today's society that we need to look at. And so it's not just that cut and dry like a lot of people think it is. codes of ethics. So there's a code of conduct, and then there's also considered codes of ethics. These offer a set of values, principles, and standards to guide decision making. Now, when you think of, okay, if ethical behavior is the act of doing what is right based on moral principles and values, then why would we need a set of values, principles, and standards that guide our decision making to do the right thing? And that's where a lot of the confusion comes in, and a lot of the frustration comes in when people are trying to do the right thing. So when we're looking at social workers, their codes of conduct fall under the Texas Administration Code, Chapter 781. Some of you all may not even know we had a Texas Administrative Code, but these are where a lot of the rules and a lot of regulations dictating occupations come in. Chapter 7881 is specifically to social workers. So the code of conduct talks about all social workers must observe and comply with the code of conduct and the standards of the practice. That's again another very general statement, but what exactly does that mean? Any violation of these codes of conduct or these standards of the practice will constitute unethical conduct. So you have to know this code. You have to know what this code means and what it says, because a violation can jeopardize your license. Constitutes unethical conduct or conduct that discredits or tends to discredit the profession. So codes of conduct are very, very important. And I bet if we did a poll of the 304 people that are on right now, most of you all have never ever looked at your codes of conduct dealing with your occupation, or you were aware that there was one there, or some people might not even be aware that there's actually a code of conduct that has to even be looked at. And we're taught, as we go through. I remember when I went through the police academy, we were taught certain things through the academy, but we weren't told to read this code of conduct or this, look at this exact guidelines. Attorneys, same way. There's classes we would take in law school that would direct you to what that was, but you didn't go word for word through each one of them. But like the law, ignorance of the code of conduct is no excuse. You have to know what the code says and have to abide by it. So what are some of the things that we look at when we're looking at this code of conduct? Some of them are very, to me, common sense. What does it mean to you cannot discriminate? Now, cannot discriminate in the general sense means you can't treat people differently. You can't do actions or words or anything towards one category of person versus another category of person. But it's not that simple, because the discrimination laws specifically deal with federally protected classes. I used to teach this during I was an adjunct professor for many years, and I would teach state and local government and federal government, and we would talk about federally protected classes. And 20 years ago, I would teach my class and I would tell them, okay, the federally protected classes are pretty much, you can count them on one hand at that point. There was age, there was religion, there was gender, there was disability, and so we all kind of know those general ones. And I would tell them at that point, there is not a federally protected class for gender identity discrimination or homosexuality discrimination, or however you want to put it, because there was nothing written in the federal laws at that point that protected people that in those categories. And so was it discrimination if I, as an employer, treated a gay person differently than a non-gay person? At that point, it was not a crime, and it wasn't a violation of codes of conduct, which is really weird when we think about it today, isn't it? Because that is a protected class now. And so sometimes we get all tied up in these political arguments about what should be done, what shouldn't be done. The one is that's in the news right now is transgender, and transgender dealing with the military and all. And sometimes I personally I get frustrated and think enough is enough. Why are we talking about this? Why is it in the news all the time? Well, part of the reason it is because of federally protected classes. Because whatever the laws determine is protected is what you cannot discriminate against. Now, is it right to discriminate against somebody else? No. For instance, is there a protected class for certain weights or heights or colors of your hair or colors of your eyes? Those aren't federally protected classes. Now, can they be tied to some of the federally protected classes? Yes. But those in and of themselves are not federally protected. And so can I legally discriminate against somebody like that? Yes, you can, but is it right? Is it the proper thing to do? No, it's not. So that's where these a lot of these codes of conduct really get what I call gray. They're not black and white because violating certain rules is you can do the wrong thing, but it still is not violating a certain rule. So there, you shall give credentials and qualifications. One of the things that is required by most medical people and people who work in the social services area, you have to provide your credentials. That's why when you go to hospitals, when you go to places, people are wearing lanyards with things around their neck. It is a required code under the code of ethics that you must tell people who you are and what you do. You can only provide services within your professional competency. This is, again, another very gray area because a social worker is not a social worker is not a social worker, just like an attorney is not an attorney is not an attorney. We all say, okay, I'm a lawyer, so I can pretty much do anything under the law. That is not true. And that is not true under the codes of conduct. Now, legally, can I practice law in pretty much any area that I want to? Sure, I can. The only area I'm forbidden to practice law in is patent type law because there is a specific requirement that says patent lawyers have to be engineers. They have to pass certain special additional tests to be able to do patent work. But can I do family law? Can I do bankruptcy law? Can I do anything else? Sure, I can. But is that within my professional competency? No, it is not, because I am an estate planning and elder law attorney. I have been an estate planning and elder law attorney for about 18 years now. Prior to that, I was a litigator. I was a trial attorney. I did civil litigation. I did plaintiff's work and I did defense work. And a big area of the work I did for quite a while was employment work. I sued employers for wrongful termination. I also defended police officers. I defended detention officers. I defended sheriff's deputies when they got accused of doing something wrong on duty. So I was very well versed in employment law. Somebody asked me an employment law question today. Is that within my professional competency? Not a chance, because I've been out of it for so many years. I have no idea what the employment laws are at this point. So that's where people get themselves in trouble, and attorneys get themselves in trouble, and social workers can too, and so can licensed therapists, counselors, because we try to give advice or we help people in areas that we are not up to speed on. And that is very, very important. And I've seen a lot of people get in trouble for doing that. Lastly, shall maintain and improve professional knowledge and skills. You have to stay up to speed on whatever your occupation is. Now, based on what I just said, does that mean that I, as an attorney, have to maintain and improve my professional knowledge and skills in all areas of the law? No, I only have to do that within the area that I practice. So I don't know family law. I don't know divorce law. I don't know adoption law. I don't have to keep up to speed on that unless I'm going to be providing those services to clients. And so you have to maintain and improve your professional knowledge and skill in the area that you are working specifically in. You must provide services based on assessment, evaluation, and diagnosis of a client. Now, that one sounds like common sense. Well, I can't help somebody unless I assess them, evaluate them, and diagnose what their issue is. But unfortunately, people do that. They'll start helping somebody and they haven't properly taken. And that's where a lot of complaints and grievances come, is they'll say, for instance, the social worker was helping me and it was obvious they didn't realize I was suicidal. They just thought I was fighting depression. So you don't want to put yourself in a position where you're helping somebody without knowing the big picture, the full picture of what this person is going through that you're assisting. You shall safeguard the client's rights and confidentiality. Again, that's a pretty common one in most occupations. There is a confidentiality issue with medical and legal and any most professional occupations. But a lot of us violate that on a daily basis. We go home and we talk to our spouses about what our clients did today or what we did today. Now, maybe think, oh, well, I'm not telling names, I'm not saying who it is, but quite often you get in trouble by explaining things to the point where you're like, oh, I know who that is. I know who they're talking about. Or you're at a party or you're at a networking event and you're sharing stories. Those can get people in trouble for violating confidentiality without intentionally violating confidentiality. So that's a real hard one that I think people really need to pay attention to, what they're saying, what they're doing, what they're exposing. Set and maintain professional boundaries. Of course, with that one, you have to protect yourself and protect others about within the profession. Shall not have sexual contact with a client or former client. That's one of those that when you first read it, we shouldn't even have to have that in there, should we? That's pretty common sense, but apparently it's not, because that one is violated, and we hear about that one being violated in the news a lot, a lot, a lot in all occupations. I'll use teachers, for instance. We hear stories all the time of male teachers doing inappropriate things with their students, female teachers even doing inappropriate things with their students. There's famous cases where I think a female teacher was dating and had a relationship and then eventually married after it was all over, a 12-year-old boy she was involved with. So this is one of those that all of us know it. All of us know this is wrong, but it is violated way, way, way too often. And a lot of times it's violated in the former client area because we're thinking, okay, there's no relationship, there's no professional relationship anymore. So now I can have a relationship with this person that I met through my occupation. That usually works out okay until there's a breakup. And then when there's a breakup, that's when the complaints happen. That's when the grievances get filed. That's when people get into serious trouble. Shall refrain from providing services while impaired by physical health, mental health, medical condition, or by medication, drugs, or alcohol. Now, we always know the medication, drugs, and alcohol. You're not supposed to be providing services when you're taking stuff that makes you not think straight or drinking. We heard one just the other day of apparently they pulled a pilot off a plane. He was pulled over for DWI on his way to the airport to go fly a plane with many people on it. So we know those are easy, but the first ones are what can get people in trouble. But again, we all do it because we might be physically impaired by our physical or mental health because we're not feeling well. We've been fighting the flu. We've been fighting colds, whatever. We're not quite thinking straight. How often do you say, I feel like I'm in a fog. I can function, but I'm just not quite, my mind's not quite working right. Can that get you in trouble? Yes, it can. But then we walk that fine line when we say, it's not always easy to say what's ethical and what's not. You walk that fine line because I got to go to work. They're telling me that I need to come in. They're short. We don't have enough people on staff. We don't have this. They're wanting me to come to work even though I'm sick. And so that is a real judgment call based on how you personally are. But But I always say, I try to err on the side of caution of, okay, if I'm not feeling right and my head is not right and I'm not thinking right, then I need to stay home. And I need to not put myself or my clients in jeopardy of me not making proper decisions because I'm not all there. You shall not exploit your position of trust. This is taking advantage, and often this one comes in along with the sexual conduct one, is people use their position to get somebody to do something that maybe they wouldn't do, but for acting on behalf of an authority figure, and we hear that all the time. And that's what they say with teachers and students. A teacher is an authority figure. And even if they get into a relationship together, it's not a balanced relationship. It's not on equal footing. And that's where a lot of people get in trouble of taking advantage of their position. So that can be in that area, but it also can be in taking advantage of people in other areas because you have a position of trust and authority. You shall evaluate a client's progress on the continuing basis and make use of supervision and consultation as indicated by the client's needs. So constant evaluation. You cannot just dive in and then not keep evaluating as you go through. If you're working with somebody for 6 months, the one thing in life that's constant is change, and that includes the client's progress and whatever's going on with them. You have to stay on top of that to make sure that you're providing the best services possible. You shall refer a client to those services that the social worker is unable to meet and terminate a relationship if you can't take care of them. And again, it goes back to what is the client's best interest. Often I think that is forgotten. I think some people, and again, not intentionally, get so wrapped up in what they're doing and what they think is best and what they think is best for the people they're taking care of that they don't think of what is in the client's best interest. And I'll tell you, in a lot of times in legal, that one is the forefront to me quite often, because there'll be situations, especially when I was a litigator, when I was doing trial work, there were situations where going to trial or following through with this lawsuit was not in my client's best interest. And it was in my best interest because the more I bill, the more I make. And the longer this drags out, the better I am. But it's not in my client's best interest. And so I would have many talks with clients about, are you sure you want to do this? This is what this is the cost it's going to be when we're looking at doing this. This is the emotional strain and the anxiety and the frustration you're going to have. This is what you're going to go through when you have to deal with the court system. And is that really in your best interest? And I think that is something that I've always thought is a very important aspect of any occupation when you're working with somebody, is stepping back and not getting so wrapped up in our abilities, our knowledge, our professional expertise, and stepping back and thinking, okay, this is what I think should be done, but is that the best thing for the client? And having those discussions with the client. Now, the National Association of Social Workers is a nationwide organization, and they provide a code of conduct, a code of ethics also. These are ethical principles again, and social workers' primary goal is to help people in need and address social problems. As you can see, a lot of code of ethics and these ethical principles are very general, whereas what we just looked at, codes of conduct, are much more specific about this is what you can and can't do. Codes of ethics are more general principles of, okay, what's your job? Your job is to help people in need, address the social problems. Your job is to challenge social injustices. Your job is to respect the dignity and the worth of people that you work with, recognize the importance of human relationships, be trustworthy, make sure you stay within your areas of competency, which is like what we talked about, but again, a very just general statement about it. and within your professional expertise. I'm having trouble talking today. Too much coffee or not enough coffee? I'm not really sure. So ethical standards that are within this code of ethics, they're a little bit more specific, but again, you'll see as we go through a lot of these, they are very general. You must have a commitment to your clients. Your primary responsibility is the well-being of the clients, not you. And again, most of y'all have heard the term fiduciary relationship, and we don't use that often in the medical field or the social worker area, the counseling area, but it's the same concept. The fiduciary relationship is where I, as the fiduciary, have to look out for the interest of the people I'm taking care of more than I look out for my interest. And so, for instance, if I'm a trustee of a trust, I have to look out for the interest of the beneficiaries, the people that are getting the benefit of this trust and the money that's in this trust. I have to invest thinking about them. I have to distribute money or not distribute money based on what I think is their best interest and best response. And I can't have any self-dealings. I can't do anything that would benefit me so that I get a better paycheck or whatever if it is not in the best interest of the people I'm taking care of. And that, again, sometimes I'm sure there's some of y'all going, that's common sense. It should be, but not always. And there's right and there's wrong, but then there's also, well, is that right or is it wrong? And that's where you get into those areas. And I always say, if you have to question if it's right or wrong, you lean on the side of making sure that the client or the customer or whoever you're taking care of is at a better advantage. Self-determination. You must respect and promote the right of clients to self-determination. What does that mean? They have a right to say what they want. Now, quite often, if there is a mental capacity issue, we kind of slough that off. And we don't think about that. And we think, okay, I'm the professional. I'm going to make these decisions, even though if they're saying they don't want it, it doesn't matter because they're really not thinking straight anyway. And so you have to let the client be involved. I do a lot of guardianships. And so one of the things that we do in our practice is guardianships for people that are legally incompetent, legal incapacitation. A big part of it is dementia, Alzheimer's as people age, but we also do special needs guardianships when a 17-year-old child now becomes an 18-year-old adult and they have autism or cerebral palsy or Down syndrome. They now need a legal guardian to take care of them. And I represent the guardian quite often, filing an application, trying to get guardianship. And I tell my clients flat out, I represent you and I have to look out for your best interest. But the big thing is I'm looking out for the best interest of the person we're taking care of. And if at any time I feel you're wanting to do things that are not in the best interest of the person we're wanting to take care of, I'm going to tell you. And if it gets too bad, I'm going to withdraw as counsel. Because we have to make sure that we're taking care of the person that needs to be cared for, and we're going to listen to them. We're going to listen to what they want, why they want it, and how they want it. And then we're going to make smart determinations about whether they know what they're doing and it's in their best interest. But we're always going to look out for their best interest. Number 1.03, informed consent. You must provide services based on valid informed consent. So you must tell them everything. You cannot tell a client only what you want to tell them. You have to give them the whole picture and give them an opportunity to consent or not consent. When clients lack the capacity to provide informed consent, you must seek permission from an appropriate third party. And that's where guardianship comes in. That's where a lot of times we do powers of attorney and documents like that, where when somebody is not able to make proper decisions for themselves, is there somebody else that has a legal authority to make those for them? Competence. You must respect themselves as competent only within the boundaries of their education, training, license, certificate, blah, blah, blah. All of that same thing again. We have to work within the areas that we are trained in that we are working in, that we have knowledge about. We cannot provide services or representation outside of our expertise area. I remember one time I was giving a presentation on estate planning, and about 2 days before, they called me and said, well, we've changed our mind. We really need you to give a presentation on bankruptcy instead. And I laughed and told them, no, you don't. You don't want me giving a presentation on bankruptcy because I don't have a clue about bankruptcy. And I don't do bankruptcy, and that's not what I've ever practiced. And so I told them, you either find somebody else or we go back to the estate planning topic, because I'm not going to provide services in any area that I don't know what exactly it is. Cultural awareness and social diversity. You should understand culture. And what does culture mean? Different people from different cultures. And one of the greatest classes I ever took was a cultural awareness class when I was a police officer. And it talked about the different cultures and important aspects of those cultures. Now, in today's society, we get this, well, if you distinguish a different culture and what they do or don't do or how they act or what's, then you could be accused of discrimination, or you can be accused of being prejudiced. I have two daughters. I have a 19-year-old and a 23-year-old. And I've made comments in the past, and my daughters will go, Dad, that you can't say that. That's prejudice. And I'm like, it's not prejudice when you're pointing out the differences between cultures, because we are all the same, but we are all different. And knowing those differences can help you be more respectful than it is, being disrespectful of what is important. And I'll give you a perfect example of what happened to me as a police officer. I went to a call one time on a family fight, and I get to the house and I could hear argument, and I had backup on the way, but I was the first and only one there. I could hear arguing and noise in the house. I knock on the door, a gentleman opens the door, and they were of Asian descent, Korean. I'm not really sure, Korean or Vietnamese. I can't remember which it was. And they're yelling and screaming in their language. And I look and I see tables knocked over. I could see that there had been a physical altercation of some kind. So I barge into the house, past the guy that opened the door, because I'm going to save the day. I'm going to go in there and make sure nobody's being hurt, everything's being taken care of. I barge in, and next thing I know, everybody in the house is turned against me. So instead of them fighting with each other anymore, now they're at me. And I backed out of the house, waited for backup, and we got control of the situation. When it was all said and done, the reason I disrespected their house, and that was a cultural thing, and I went in with my shoes on because, as you know, a lot of Asian cultures, but most of you don't know, they want you take your shoes off before you go in. I disrespected all that because I didn't think about it. And my job, I was trying to do my job as a police officer. So not knowing the culture and not being aware of the differences can cause problems. And that's why it is so important to think about that. One of the things that, they talked about in this cultural awareness class that I was on is how important family is to the Hispanic culture. And they would use examples. I took this class in El Paso. I was a police officer in El Paso, Texas, before I went off to law school. And one of the things they talked about in this class is they said, okay, have you ever noticed in the Hispanic culture how often you will hear of a child at a high school, senior in high school, valedictorian, and they have a Hispanic surname, and they have decided to stay here in El Paso and go to University of Texas, El Paso, UTEP, when they could have gone to Harvard or Yale or any other Ivy League because they're top of their class. And how many of you all have ever thought how ridiculous that is? What the heck is wrong with that kid not going and taking the opportunity to go do what they could do? And they said, you have to realize that in cultures, in the Hispanic culture, family is so very important that child would rather stay close to family than they would to go on their own. And then they compared it to the Anglo culture. And they said the Anglo culture is a much more look out for number one culture. And so for an Anglo student, they don't hesitate to say, see ya, mom, dad, I'm out of here. I'm going off to UT. I'm going off to A&M. I'm going off wherever. And I'm going to look out for what's good for me. And I'm not really care too much about staying with my family. And so looking at the differences in those cultures is very, very, very important. Conflicts of interest. Avoid conflict of interest that interfere with the existence of professional discretion. We hear that one a lot. But what exactly is a conflict of interest? And it said it should not take unfair advantage of any professional relationship or exploit others. What exactly does that mean? You don't take advantage of somebody of any professional relationship or exploit others. So you don't use your position to get an upper hand. You should not engage in relationships with clients or former clients in which there's a risk of exploitation or potential harm to the client. So you cannot get involved in any type of things where the client could possibly be harmed. And conflicts of interest are very common within almost all occupations. Within the legal field, we are constantly looking at it. We cannot represent a client if we've represented a client on the other side and things like that. Why would I not want to represent a client that I've represented another client that may be opposing them? Because I've already learned things. I've already know things about the other side. And I may even unintentionally use that information that I know to the disadvantage of either my client or my former client. And that's where your conflicts of interest come in, is whose interest are we looking at? And again, it always comes back to what are you doing that's in the best interest of the person you're taking care of or you've taken care of in the past. Privacy and confidentiality, we've talked about, again, just keeping things confidential, not disclosing confidential information, etc. Access to records. You should provide your clients with reasonable access to their records. And unfortunately, we see that as a problem. Okay, they don't allow them to see all their records, or they don't allow them to see any of their records that are that say things we really may not want them to see. So the reality is clients have access to everything that belongs to them or is about them. And we do unfortunately see that as a problem, not as much on an individual basis, but on a company basis. The hospital's administration doesn't want to completely release all the records, those kind of things. Government entities don't release all records. And so giving the client access to everything that's about them often gets people in trouble. Again, back to the sexual relationships. Should under no circumstance engage in sexual activities, inappropriate sexual communication, or sexual contact with current clients, whether such contact is consensual or forced. Where can that become a problem? And we call it flirting. People flirting with their client. Oh, it's harmless. Well, is it? Or is it inappropriate sexual communication with a client or former client? That can cause major problems. Whether such contact is consensual or forced. Again, a client is like a minor in this regard. Minors cannot consent to sex. That's why a 16-year-old girl with a 19-year-old boy is considered statutory rape, even though they're only 3 years apart. Because one is an adult and one is a child, and under the law, children cannot consent, even if they consent. They cannot legally consent. You have to look at the same way with clients. Clients can't legally consent. So even if they're consenting, it's really not you can't take it as a consent. So it says clients or clients' relatives or other individuals with whom the client may maintain a close personal relationship. So that's, again, a problem. Okay, I'm not having a relationship with my client, but I am my client's brother, sister, mother, father, daughter, son, whatever the case may be. that can also cause major problems. Should not engage sexual activities or sexual contact with former clients because of the potential for harm to the client. Should not provide clinical services to individuals with whom they have had prior sexual relationships with. That's another one that people don't think about. If you've had a relationship with this person, that pretty much prior to you ever having a professional relationship with them, that can be a problem. You're not supposed to provide professional services to somebody that you had a relationship with. Again, that is violated more often than not because it just doesn't get reported, because we all find ourselves doing favors for family or our loved one or our spouse, doing things like that and helping them in our profession, even though we had a relationship with or have a relationship with them. That just is a real thin ice. You're really treading on thin ice to do that. Physical contact. This one, to me is very, very important. Should not engage in physical contact with the client when there is a possibility of psychological harm to the client as a result to the contact. If appropriate physical contact, set clear, appropriate, and culturally sensitive boundaries. So this is, I'll use me. I'm a hugger. I love to hug. I always hug my friends. I'm a toucher. I'll put my hand on somebody's shoulder. It's just that's just my personality. And I have to watch that because one time years ago, we had some high school interns in our office, and they were sitting at the dining table. We have a lunchroom area, and they were sitting there talking. And I walked in behind them, and I'm kind of engaged in the conversation. And apparently, because I don't remember doing it, I apparently put my hand on the shoulder of one of the female interns we had, and touched her shoulder while I was talking. And I have two daughters, so I do that all the time. I put my arm around my daughters. I hug my daughters. That's my personality. Well, next thing I know, I hear, there was a complaint about inappropriate physical contact. And I'm like, what? And I honestly did not even remember it. And it ended up being, harmless, and everybody realized it was harmless. But I didn't even think twice about, did I offend this person? Did I make them uncomfortable? Because I set my hand on her shoulder. And so that can be, you can violate this ethical standard without even being aware of it. And that instance that happened to me personally made me really think now every single time I'm around people, I've got to really watch myself, because I don't want to just say, "Oh, I'm glad to see you," and hug them, and then I'm offending them because they don't want to be hugged. And so this is just one of those that can really get people in trouble by accident, not intentionally being inappropriate. But you don't think about, you have to think about what the person that you're touching, what they feel, and how they might be offended by it. Sexual harassment, we hear that all the time, includes sexual advances, sexual solicitation, requests for sexual favors, verbal, written, electronic contact of a sexual nature. We have to watch what we say, what jokes are told, those kind of things, because that's where it gets people in trouble. I had a very, very interesting case years ago where I represented a lady who worked at a bank, and one of her managers would come in, another female, would come in, and she would brag about her, what I'll call sexcapades, with married men and other people. So she would come in and apparently in explicit detail tell the other employees about what she did. And my lady was very, very offended by it. She filed a complaint with the bank, and the bank fired her. So we filed a lawsuit against the bank. We're in court, and we're getting the bank is filing for what's called a motion for summary judgment. They're asking that the court dismiss the case because we don't have a legal basis for our argument. And their argument was not that this lady, this supervisor, had not done what she did. Their argument was she was an equal opportunity harasser, meaning she would tell these stories to both men and women. She wouldn't tell them to just one gender. And at that point in the law, sexual harassment said you had to address it toward a specific gender. So it was you're harassing men, you're harassing women, and it could be same sex. So a man could be harassing a man, a woman could be harassing a woman, but it was 1-to-1. And their argument was yes, her action was inappropriate, but it wasn't illegal. And the court poured our case out because the law at that time was exactly that. And I was just appalled. I'm like, are you kidding me? This lady can go in and be as inappropriate as she was and talk about sex all you would be floored if you knew what the things were said. But it's okay under the law as long as she told it to both men and women. It made no sense to me whatsoever, but that was a really eye opener to me about what exactly is sexual harassment and what are the laws pertaining to it. But in the code of conduct, it's just don't do it. Don't talk about it. Don't joke about it. Don't post things about it. Don't do anything that could be sexually offensive to anybody. Derogatory language is another one that just, bad language, inappropriate electronic communications. You can get in trouble for blowing off steam because you're ticked off about whatever happened. You have to really watch what you're saying. I guess that's a good thing is this AI. I've seen these commercials where somebody will dictate what they're thinking and then the AI makes it sound good. Maybe that's a good idea now so if you're mad, you can dictate a mad email and then have AI fix it so you don't sound inappropriate or derogatory. Okay, payment for services. You should ensure that fees are fair. Again, overcharging people, that's a real gray area, I think, about what is and what isn't a fair price based on your services provided. Consideration should be given to the client's ability to pay. And I think we as attorneys are bad about that, is we decide, okay, this is what I'm going to charge, and this is what I'm going to charge no matter what. And we don't think about, okay, what is the client's situation? What is their financial situation like? What are they able to pay? And should I think about, adjusting my fees based on their situation? And I do that all the time. I'm not trying to pat myself on the back, but I take that into consideration. And a lot of the estate planning that we do, there are a lot of different options that people can choose when they're trying to decide what to do. And I take into consideration based on what they've told me about their financial situation. I'll tell them, based on what you're telling me, this may be the best plan for you and this may be the best way to go, but the cost of this is this. And I have another option where we can do this for less expensive. So I explain that to them and I give them the choice. And that's what I think when you're considering what their situation is giving them options about what they can and can't do based on their financial situation. Clients who lack decision-making capacity, you should take reasonable steps to safeguard the interests and the rights of those clients. That one makes sense, is when you're dealing with somebody that can't care for themselves, you have to take extra caution to make sure they're cared for and they're cared for properly. Interruption of services. You should make reasonable efforts to ensure continuity of services in the event the services are interrupted. That comes into play a lot of times within I want to say employment situation. I have it all the time with my law firm. We have had a number of associate attorneys over the years, and an associate attorney may be assigned a client and taking care of that client, and then the associate attorney quits for some reason. They get a better job or whatever, they move on. We got to make sure that that client is taken care of by somebody else. And I'm not going to lie, the ball gets dropped once in a while. And sometimes when, you have an attorney and they're taking care of 50 different cases, and now they leave. We've got to figure out how do we rearrange those 50 cases with somebody else. And sometimes people get forgotten about, and that is a very big no-no. And so you do everything you can not to do it, but the big thing you can be accused of violating ethical standards by not continuing their services and making sure they're continue to be taken care of. And referral of services. It's very important that you refer out clients that you can't properly take care of. And I don't know how bad that is in the social work area or the licensed therapist counselor area, but it's bad in the legal area because there are unfortunately attorneys that will take cases they should not take because they want the money or need the money. And I see that more often than I would like to admit. Is I have people that are taken care of, and doing estate planning and elder law, we clean up a lot of messes. And part of it is fixing problems that other attorneys have messed up. And it's because that other attorney wasn't an expert or wasn't up to speed in the area of estate planning and provided services to a client that they should not have provided. And so that's very, very important. It's very important that you know your limitations, you know your expertise, you stay within your expertise. And if it's not within your expertise, you don't try to make it your expertise. Because some people will do it even harmlessly. They'll like, well, I'll learn it. I'll figure it out. I'll help. I want to help this client, so I'll figure out what they need. Well, maybe that's not the best way to do it. Maybe it's better to get somebody else involved and try and refer them to other services. And termination of services. This one gets people in a lot of trouble. Is canceling the service, dealing with the money at the end. Does the client still owe you money, or are they should they be entitled to a refund of some certain money? When you terminate them, and the service is no longer required, do you make sure that there are other avenues that they can hire somebody else, or that there's somebody else that can be taking care of them? And so I'm going to let you guys read this. You guys will get these copies of these slides after it's over, but it really is you're not putting the client in danger of hurting themselves or doing something by you not providing services without having somebody else there to step in. So termination of services can be a very touchy area. Additional ethical standards. I'm not going to go through every one of them, but so that you know they're there if you want to look at them. Chapter 2 within the Code of Ethics deals with ethical responsibilities to your colleagues. 3, ethical responsibilities in the practice setting. 4, ethical responsibilities as professionals. 5, ethical responsibilities as social work profession. And 6, to the broader society. Texas Administration Code Chapter 553 deals with training and management of assisted living facilities. So people that are out there that are managing assisted living facilities have to have a certain amount of training. After August 2000, a manager must have completed at least one educational course on the management of assisted living, which includes information on assisted living standards, resident characteristics, et cetera, et cetera, et cetera. So I'll let you all read that more. If there are some people on there that are administrators within assisted living facilities, you need to know Texas Administration Code Title 26, Chapter 553. The American Counseling Association also has a code of ethics, and their statement is: a mission of the American Counseling Association is to enhance the quality of life in society by promoting the development of the profession, advancing counseling profession, and using the profession and practice of counseling to promote and respect human dignity and diversity. Professional values, they're important. 1, enhancing human development throughout the lifespan, honoring diversity, and embracing multicultural approach. See, those should sound familiar because we've already talked about those same topics in the Code of Ethics, and that's why I say a lot of it is overlapping, and we all have the same type of things that we need to be aware of. Promoting social justice, we heard that one under social worker. Safeguarding the integrity of the counselor-client relationship, confidentiality, those kind of things. and practicing in a competent and ethical manner, staying within your lane, doing the counseling that you're trained to do, not trying to provide something you're not. The fundamental principles of professional ethic behaviors are, and I'm not going to read all of them: autonomy, non-malfeasance, beneficence, justice, fidelity, and veracity. Again, that working and doing the right thing. Texas Administration Code Title 22, Chapter 681 deals with the Texas State Board of Examiners for Professional Counselors. Again, if you want to know anything, look at the administrative code. That has pretty much every guideline when it deals with our professions. Ethical dilemmas in healthcare. Now, let me see where we go. We talked a little bit about COVID issues in this. I'm trying to see where my thing is because I want to open it up. We're getting close to about 25 minutes left, and I like to have people share some of the ethical issues that they've dealt with and deal with questions. But just really quickly, during COVID, a lot of ethical dilemmas came up, and a lot of ethical dilemmas dealing with treatment, like the question of how do we really ration the supplies? Remember when there was a shortage of certain things? Who gets what and who's entitled to what, and if I give it to one person, do I have enough to take care of others? That causes major problems with treatments. Talking about ICUs, ventilators, and staff shortage. There was serious staff shortages. The purpose, if you are trying to save the severely sick, is it worth the time to save somebody really sick when somebody else might be saved? That's a huge dilemma in the medical area. Trying to seek or save as many of the severely sick as you can. There was a rationing of COVID-19 testing at certain times, COVID-19 vaccines. There was all kinds of issues dealing with proper care of patients when we're in a pandemic that everybody, is kind of flying by the seat of their pants and learning as they go. There was shortage of COVID-19 testing. COVID-19 pandemic involved competing obligations for healthcare workers. Do I go to work and take care of somebody and possibly expose myself and my family, or do I stay home and protect myself and my family? So there was a lot of ethical dilemmas during that COVID-19 time that I'm sure a lot of you all on the call can share with me more than even what I can share on this screen. When vaccine became available, there was policy making issues, there were public health official issues, there was what is it safe, is it not safe, should you take it, should you not take it? There's still issues concerning it right now. I just heard one of the big things in this Trump administration is reinstating and back pay for all military personnel who were let go for refusing to take the COVID-19 vaccine. Talk about, all these people that were let go at the beginning when they refused, when it was a mandatory thing. And that is a big controversy. People on both sides of the fence about that. But is that an ethical issue? Yes, it is. There's big ethical issues dealing with health organizations during that pandemic. The AMA, American Association of Medical Examiners Journal of Ethics, difficult decisions lie ahead that raised that was again dealing with COVID, rationing issues, imposing restriction issues, and upholding our professional duty to treat in the face of personal danger. The Texas disciplinary rules of professional conduct. Remember, one of the things that this will be used against people if they are accused of violating ethical rules. These are minimum standards. These are minimum standards of conduct for lawyers, minimum standards of conduct for social workers, for licensed therapists, for counselors, for assisted living administrators. The code requires just the minimum standards, and therefore you're supposed to act above and beyond what these minimum standards say. I'm going to skip over that other lawyer thing. here are some resources that'll be provided to you in the slides on some Texas ethics resources that people can look at. And let's talk a little bit about ethical case studies. And before I jump into the ones that I've got on the screen, I think, Sheila, I'm going to turn it over to you and see if there's been anything put in the chat, or let's talk about a little bit of what other people are sharing with us.
Well, there is one that I do want to bring up. And she put it in the chat, but there's been a couple people say, please have him address this. Okay, let me get to it. On. Right. No, hold on. My screen's jumping. Darn, it's from Rochelle, and she's asking, so is it still considered sexual harassment if the person that you're dealing with has dementia or Alzheimer's?
Yes, there is not. So I guess
Yeah.
My question in reading that is it sexual harassment if I, as a professional, am doing inappropriate sexual advances or joking to a person that's got dementia or Alzheimer's? Of course it is.
Yes.
That's easy. It's not sexual harassment if the person with dementia or Alzheimer's is saying inappropriate things, because you have to take into consideration the mental capacity of the person and them saying and doing the things they don't know they're saying and doing. And I'm sure assisted living, skilled nursing professionals deal with that. They deal with somebody that's got Alzheimer's, dementia, that are male patients coming on to female patients. And can the facility be held responsible for allowing things like that to happen? Yes, they can. They have to take action to protect their patients from that type of thing. But is it considered sexual harassment on the person doing it when they don't know what they're doing because their mind's not thinking straight? Then no, I can't imagine it being found that that person is responsible.
So then there's a lot of talk about this one. So then somebody said, you're saying it is different doing it for someone suffering for dementia? No. Well, it would be, in my mind, it'd be worse.
Yeah,
but I don't know.
Yeah, I agree that if you are taking advantage of somebody, I mean, it's inappropriate for any professional to do that, period. So me as a professional, I'm working, let's just say I'm working in a nursing home, I'm a CNA or whatever. It's inappropriate for me to do and say anything sexual whatsoever to the patients, no matter what their mental capacity is. But if I'm doing it knowing that their mental capacity is diminished, yes, I think it'd be far worse, and I think you get in a lot more trouble.
I just heard a story yesterday at my luncheon about someone who's had some strokes. Okay. And they now sometimes say or act out or touch someone wrong or whatever, but okay, what you have to do is just say, no, that's not okay. It's not appropriate. Please don't do this again, whatever, because that person, it's almost like they have Tourette's. They don't understand what they're doing. And that's what Fred was saying. That's different. If the person was doing it to you, you can say, no, that's not okay. Please don't do that again, or don't get close enough to the whatever. But if you were doing it to the person that you knew was impaired, then that in our mind is worse. Yes.
Well, I'll give you a real example of a story I heard. I went to a brain injury seminar one time years ago, and the speaker was talking about the former quarterback of the Pittsburgh Steelers, Roethlisberger. And Roethlisberger was accused of coming on and inappropriate sexual things with a female in a hotel, I think, if I remember it correctly. And she was talking about that happened, that inappropriate behavior happened after he was involved in that bad motorcycle accident he was involved in. And it was determined that during that motorcycle accident, one of the injuries he had suffered was to the part of the brain that tells us what to do and not to do. And so she used the example that, for instance, a man sitting someplace and looking at a very attractive woman, and his mind's thinking, oh my gosh, what I would like to do with that girl or whatever. Our brain tells us, even though our brain might think, oh, I'd really like to touch that good looking woman, our brain says, no, that's not appropriate. And it stops us from doing inappropriate action. And she was saying that his part of the brain that would be basically the stop sign was damaged, and therefore he acted out on something that he wouldn't have normally acted out on but for his diminished capacity of his brain. And I thought, okay, that makes sense when you're looking at, is it or is it not sexual harassment? You look at what the person that's doing the action, should they know better, should they not, etc. And so that's when the question comes up, is if somebody has dementia or Alzheimer's and they're doing inappropriate things, you have to take into consideration the parts of their brain that would keep them from doing inappropriate things is not there.
Okay, we've got two more. I have had ethical issues regarding release of information for minors whose parents are going through a tense and contentious divorce. One parent says yes, and the other one says no.
Yes, that I don't have an easy answer for that. And I've had that, we've discussed that. I've had that question come up. And I think that probably we would get a better answer from a divorce lawyer than from me. But I've always told my clients, if those issues come in, you don't release information unless a court order tells you to release information. And you stand by the fact of, okay, we've got a dispute between the two parents. Unless I get documentation showing which parent is the custodial parent and responsible, I can't release information until I know what. So the ethical issue becomes, again, caution. I would rather hold back the information and demand proof of what I'm supposed to do than release it and get in trouble for inappropriate releasing of confidential information.
Okay, the next one. How do you honor self-care, which is very important in our industry, while putting the patient first? Is it unreasonable to consider our own needs and boundaries that keep us at our best for our capacity to treat our patients?
That's a good question. So ethically, under the ethical guidelines, you are to look out for your patient's interest more than yours. Period. That's what the ethical rules say. You look out for their interest and their best interest more than you look out for your best interest. Reality steps in, and that's where these ethical dilemmas really come in. And that's where I say sometimes it's not just, oh, let's do the right thing or not do the right thing. It's not black and white. Unfortunately, there's a lot of gray in a lot of these things. Which is it best? And again, I think you've got to weigh the options of, is it in my client's best interest for me to put myself in a position that I might get hurt or I might get sick or I might, and there's a balance there of, okay, I've got to make a decision, and they're not always easy decisions. And again, there's not always the right decision versus the wrong decision. There can be more than one right decision. But again, when it comes back to it, looking at the ethical rules, you just have to keep into consideration your client's best interest over your best interest. and which is that. But sometimes, again, it is in the client's best interest if I don't put myself in jeopardy. Hope that somewhat answers that question that can't really be answered completely.
Okay, and this one is really good. I have a question about those counselors that advertise themselves as being, for example, DBT informed. I don't
I don't know what DBT informed is.
I don't either, or familiar, which I'm assuming means you have not been trained or certified. Is it ethical to do that? Doesn't that detract from counselors who have been trained and certified or clients who are looking for specific therapy treatment? Please
Okay.
tell us what that is, because we don't know
Well,
what that is.
even while we wait for that, Sheila, just looking at the question, it to me is deceptive for anybody to say they are informed or familiar with something because they're trying to sell themselves as having knowledge they have not received a certification in. For instance, in the legal field, there are certain areas within the legal field that we have a board of specialty examinations. So I can become a board certified specialist in areas like family law, estate planning, criminal defense, criminal law, personal injury. And if I am not certified, if I am not a board certified specialist, the state bar rules say I cannot say I specialize in estate planning if I've not passed this test. Can I say my practice is exclusively in the area of estate planning and elder law? Yes, the board rules it's not an ethical violation to say my area of expertise, my area of focus is in this area of law, even though I'm not certified under a special test. Because there's a lot of attorneys, they don't want to take the test. They don't want to do it. I mean, I know attorneys that are better in certain areas of law, far better than the people that take the test. Because, like anything else, if you take the test, that means you can pass a test. That doesn't mean you're great in that area. I don't know if that's the same within counselors. I don't know if why,
Well, the word means, the thing means dialectical behavior theory and a therapy. And then it says, this person says it's a modality of mental health treatment like cognitive behavioral therapy, and it does not require certification.
well, and then is that an ethical violation? No. If it doesn't require certification, then people are allowed to say they are informed or they're knowledgeable in that area. Again, a lot of times in situations like that, it depends on what the board, the licensing entity that oversees the occupation, what they say you can and cannot say.
Okay.
Now, it is deceptive to me if people say it and they're not.
Yes.
So I'll give you a perfect example. I've got people that'll say, well, I went to this guy, he said he was an estate planning attorney. Well, when I look him up, he does estate planning, criminal law, civil, their practice, they're what we call a general practitioner, which you don't see much anymore at all, except in small communities. But to me, somebody like that saying they're an estate planning attorney, that's deceptive because they're not an estate planning attorney. They may know how to do a little bit of estate planning, but they're not an estate planning attorney. And so does the law does the State Bar of Texas allow them to say that? Yeah, they can say it, and it's not a violation of the ethical rules, but is it questionable? Sure. So I think that's the same thing. What do your rules allow and what do they not allow? And even if they allow it, it may not be the right thing to do or say.
Okay. The next one says, is there an ethical obligation from the healthcare staff at a hospital to ensure a proper discharge plan is in place for seniors who do not have insurance or any income, and their health issues exceed their capacity to properly care for themselves, which means they need a higher level of care. They will not be able to go to a shelter due to their health needs.
Okay, so I would say that that is an ethical responsibility of the administration of the facility that is letting them go. Is it a specific ethical responsibility of the nurse, of the social worker, of the people employed? I think it's their ethical responsibility to document and notify when there's concerns. But ultimately, it is the administration of the facility to make sure they don't just turn somebody out on the street and they're not cared for. So that, yes, there's been many lawsuits that come back on somebody being released when they shouldn't have been released. And I mean, I'll give you a example. When I was a police officer, I was in El Paso and I'm driving down a not so great area of town, and this man is walking in the middle of the street in the middle of July when it's 110 degrees in El Paso, and he's got a coat on and everything else, and I had to pull over to not run him over. And it was obvious immediately he was homeless and he was mentally unstable because he was wearing clothes not appropriate for the environment. I get him in the car and I start talking to him, and I come to find out that he was released from the mental institution in Big Springs, Texas, which is our state mental facility. And he is from California, and the state mental facility discharged him. And since they could not legally send him all the way to California, apparently, they legally sent him as far in Texas as they could send him. So they basically put him on a bus and sent him to El Paso, the farthest point in Texas, close to California. And this homeless man is walking down the street, doesn't know anybody in El Paso, is completely lost and definitely not mentally there. And they just dumped him, in my opinion. We picked him up. I took him down to the homeless shelter. We talked to them. They took him and they said they would make all the arrangements to get him home. But to me, that is criminal for a state agency to do something like that. But yes, that happens. It is wrong. It is, and the liability goes back on the administration.
Can I get you first of all to advance the slides to your contact information?
Okay, let me see if I can get this thing to work.
There we go. So, well, that went fast. We'll come back to it. That will be in the follow-up email will be Fred's contact information.
I'm trying to get back to it. We'll see. I get it's on that one.
There you go. It just went away real quick. There you go. Here, if anybody has any questions, here is Fred's contact information. It will also be in the follow-up email. You should have this. Everyone should have the link to the slides. I put it in the chat just a few minutes ago. That also went out in the email with your with the link for today's webinar. But I want to go over CEUs since we're getting to the end of our advertised period of time. And then if you would like to answer more questions, that would be great. If you're busy, that's understandable as well. For those of you that are joining us today for CEUs, we're providing complimentary CEUs for licensed social workers and licensed professional counselors in the state of Texas. And these are ethic CEUs. Today's webinar is worth 1.5 hours of CEU credits. You must complete the entire webinar live and the Q&A up to the time we've advertised the event to end, which is just now. You must also take You must take the Google evaluation survey. When you close out of Zoom today, it should ask you if you'd like to take a short survey. That will take you to our survey. If that doesn't happen, you should also receive a follow-up email from me tomorrow that will have the survey link and the contact information for Fred in there. It'll be open for about a week for you to fill out the evaluation form, and then give us a bit to get the certificates out to you. Please, it's taken us a while, but we will get them out to you. Real quick, if you have a different license in Texas or you have a license outside of Texas, it doesn't matter. You can still go through the process, get the certificate, but please note there's no guarantee that the jurisdiction will take it. I've heard people tell me they've been able to use them, and I've had jurisdictions reach out to me for more information, but there's no guarantee of that. So I'm going to turn it back over to you guys. If you guys need to tell us how your time needs to be managed, if you would. Yes.
I've got one more, Fred, that's good. I'd love for you to
Okay,
answer.
before you do, Sheila,
Okay.
My information, and I do questions. I help people after these webinars all the time, and I do not charge or do anything to help people and guide them in the right direction unless somebody finds the need to hire us for what services we provide. But I would ask I noticed the slide gave my email address, fred@heymanhogue.com. I would ask that you please include Sheila at heymanhogue.com, because she looks at her email far more than I do. And I'm so busy that sometimes I don't look at my email honestly for days. And so if it's a question that needs to be addressed, copy Sheila and she'll make sure I get it and make sure we get you the help you need.
Very, very good.
Okay, this one is really good. Marty, you'll like this too. I have seen licensed social worker services being advertised with the approach of being very open, approachable, etc., with a disclaimer stating that they curse, use jargon, and such. Personally, I believe this goes against the code of ethics, as it does not sound like professional behavior. My question is does this depend on the client? My approach is to remain professional, as I feel that otherwise it is creating inappropriate boundaries and more of a friendship type of relationship.
So disclaimers help a lot of people, and disclaimers allow, I'll give you a perfect example that sometimes disclaimers allow people to violate the law even. When internet estate planning became very big, and I think one of the first big ones that everybody knows about is LegalZoom. When LegalZoom came about, and then all these others that are providing online estate planning, I used to get so many bad documents in my office that at one point years ago, I thought about setting up my own website and doing minimum required Texas documents, so that if a do-it-yourselfer wanted to do it online, they could, at least if they went to my website, they were getting good documents. And I called the State Bar of Texas and left a message for our ethics attorney. And I told her what I wanted to do. And I said, I want to make sure I'm compliant with State Bar rules. And she calls me back and she says, Mr. Heyman, I understand what you want to do. I understand you want to, you said you wanted to comply with State Bar rules. And I said, yes, ma'am. And she starts laughing. And I sat there for a minute wondering why she was laughing. And then she says, Mr. Heyman, I'm not laughing at you. I'm laughing at our wonderful state government. Because would you believe that apparently, and this is how she put it, she said, apparently LegalZoom has gotten to the legislature before you could, because there is a law hidden in the Texas government code that says if you are providing documents over the internet, as long as you have a disclaimer saying you are not a substitute for an attorney or you're not a law office, then you have zero liability whatsoever. and you can sell whatever you want, and it's nothing more than selling any other product over the internet. And so she says basically they have passed a law protecting these companies so that they can provide horrible documents and there's no liability. You can't go back on them. And so I looked it up, and sure enough, it's in the Texas government code. And the way she put it, she says it's no more than a person selling a pin over the internet. And I thought to myself after I got off the phone, if I sell you a pin, how do you know when it works? Well, when you use it. If I sell you a will, how do you know when it works? When it's too late, after the person's passed away and now we're probating the will and the will's not good. Can you go back on the internet provider? No, you cannot, because they have a legal protection within the law. As long as they have a disclaimer, they're okay. Now, the description you're giving, I would find it very hard to believe there's an exception that says if you disclaim that we cuss and we say foul language, I don't think that exempts them from abiding by the ethical rule that says you can't do it. And so I would be very surprised, but that's what you have to look at. You have to look at, is there a rule or a law or something in there that says, if I provide a disclaimer, am I protected? And so some people provide disclaimers thinking they're automatically protected, and they're not. And that's what I would think in the situation you're describing. I don't think that me saying, well, I drop the F-bomb whenever I want to, gives me permission to drop the F-bomb.
All right, here's a good one. What is the legalities around a Texas licensed therapist working with a client via video, so on Zoom or whatever, who resides in Texas, but may be out of state at the time?
Okay.
I guess
I don't know the exact answer to that. That is one that would need to be looked up. But I would think, as long as you are licensed in Texas, you can provide services to Texas residents, no matter where you're sitting. If I'm in Colorado on vacation, I can still provide legal representation to my Texas clients by Zoom. Now, if I've moved to Colorado and I'm living there, as long as I'm licensed in Texas, I can still provide legal representation to Texas residents, but that is allowed in the Texas rules. Our State Bar of Texas rules say if you've got a Texas license, you can practice in Texas. It doesn't say you can't, you have to be in person versus Zoom.
Okay.
So I don't know what the therapist law would be.
Well, the therapist is not the one out of state, it's the client.
Okay. If the client is out of state, then I would say no. Because unless they're on vacation, if they're a Texas resident on vacation, sure, I don't see a problem with that. But if they're a Texas resident who moved to Colorado, now they're a Colorado resident, I would think you would need to be licensed in Colorado to provide services to a Colorado resident. But again, I'm guessing on this question because that one would need to be looked up. It would have to be looked up in what the rules are for providing that service.
According to the comments I'm seeing, you're correct.
Okay.
Can I ask you a question? Are you talking about counseling services?
Yes.
Yes, there now is, Texas now is part of a multi-state agreement. And this came subsequent to COVID. For COVID, they were given a temporary allowance to provide services across state lines. I mean, for people in different states. Now there's many states that have agreed to this multi-state. If you're licensed in Texas and you have a client that you're going to serve it via Zoom in one of the other states that's part of the agreement, then you can. I can't tell you what states they are. I can tell you Texas is is now part of that. I know California's not, because I just got in a situation myself for that. But Texas is part of it.
Yeah, that's definitely one of those areas you want to make sure you know what the rules and what the law is.
Yeah.
I do know that when my daughter graduated from the University of Alabama, and for those other Roll Tide fans out there, Roll Tide. But when she was at Alabama, she was here on vacation, or I can't remember what she was here for. She could do a Zoom meeting with her counselor. She had a counselor out there, but she had a doctor out there also, and she could not do a telemed with the doctor. She couldn't, she had to go back to Alabama and have an in-person meeting with the doctor. And so again, it depends on what the rules say of what you can and cannot provide by way of virtual meetings with out-of-state people.
Well, the comments are, Marty and Fred, that multi-state compact is for psychologists, but not social workers.
Oh, and not licensed therapists, not licensed counselors?
I'm not seeing that.
That's what people need to find out. People need to look that up if that's.
Because there is a difference between a psychologist and a therapist.
Yes. And I apologize if I misled anybody, because I don't know how far it extends, or who it extends to. I do know things have changed, and COVID's brought a lot of those changes about.
Anything else, Sheila, before we wrap up?
No, there's just more comments. It says that has been approved for social workers in Louisiana, but Texas has not yet agreed to it.
I see.
Louisiana is its own different world.
I know it is. And for those of you that don't know what Fred is talking about, I found this out, but before I went to work here on a vacation, there is one state in the United States and one province in Canada that have a different rule of law than anyone else. It's Napoleonic law, and it is Louisiana in the United States, and it is Quebec actually correctly, in Canada. Those laws are different, like Fred says, than anyone else. So
all the rest of the country is under English common law, and Louisiana is under French Napoleonic law.
So their law that and when you come here, then you need to change everything, because it doesn't work.
Yeah. Yeah, I get people move here from Louisiana that want to keep their Louisiana trust, and it just doesn't work, because if you become a Texas resident, you need to convert it over to a Texas trust, for instance. Okay.
I think that's it, Fred.
Well, thank you guys. Thank everybody for listening. Thank you all for the questions and the comments. I hope you all got something out of it. If we can assist you at all in the future, we're available. But until then, God bless.
Please remember to take the survey and look out for the follow-up email. It will have both Fred and Sheila's email addresses in it. Thank you so very much, and y'all have a wonderful day. Fred, Sheila, thank you.
Thank you, Marty.
Thank
Talk to you later.
As
Bye-bye.
always.
Bye-bye.